On Tuesday, the justices heard oral arguments in this case, which has been bubbling up for 2 years, ever since Aereo came onto the market in New York City, offering customers a new way to watch over-the-airwaves television stations via the internet. Aereo charges $8 a month, and it disrupts the existing ecosystem for television in the United States. It has its own array of tiny antennas that allow customers to watch TV without having to pay for cable or satellite, and thus without having to pay for those retransmission fees. All of the broadcasters say this is a blatant copyright violation. And here on Tuesday, we heard a vigorous debate about what Aereo really is. The broadcasters say it's a gimmick that should be essentially ruled to be illegal and made extinct.
I think what's at stake at this case is really the nature of broadcast television as we know it. Because if a company like Aereo can somehow provide content to lots of paying strangers without engaged in a public performance, I think the networks, at least some of them, will have to rethink the way that they provide content. Because I think the traditional understanding has been, certainly since 1976, that when somebody like a cable company retransmits broadcast over the airwaves, from the airwaves to their cable consumers, they're certainly engaged in public performance. And if that changes, particularly if it changes in a way that suggests that over-the-air broadcasts are uniquely vulnerable to this kind of maneuvering, I do think that companies are going to have to take that into account in determining where they provide their content and what formats they use.
Aereo says this is not about copyright at all. They say what they're doing is perfectly legal because of the way they've set up their array of antennas.
From our perspective, the issue in the case was whether consumers who've always had a right to have an antenna and a DVR in their home and to make copies of local over-the-air broadcast television, that right should be infringed at all simply by moving the antenna and the DVR to the cloud. We're cautiously optimistic, based on the way the hearing went today, that the court understood that when a person watching over-the-air broadcast television in his or her home is engaging in a private performance and not a public performance that would implicate the Copyright Act.
There were also lots of questions about how this case would affect the cloud computing industry. There are lots of startups, not just Aereo, that revolve around remote storage, the idea that you might have a piece of media that's stored on the internet instead of on your own computer. There was clear concern from the justices about whether an overly broad ruling would hurt lots of other companies that also involve cloud computing. The signal from the justices was that we should expect some sort of narrow ruling in this case. Several of the justices also challenged the way that Aereo is set up. Chief Justice John Roberts repeatedly asked about why they need to have thousands of tiny antennas instead of one big antenna. Essentially, he was saying, aren't you, Aereo, just trying to skirt copyright law by having all these tiny antennas? The justices will rule at some point in the next 2 months, and until then, Aereo will remain in limbo.